Welcome to the annual review of the Supreme Court's term criminal side cases. I think this is the 20-something fourth year that we've done this panel, and some of you have been here for almost all of those years. Thanks for coming. You should have, when you came in, gotten a copy of this booklet, and if you didn't, I'm sure you can get one out there, which summarizes the work of the term. We are really fortunate to have what I'm going to call today the All-Columbia panel, because everybody's got an attachment to Columbia. I'm going to tell you a little bit about them, not nearly enough to do them justice, give you a brief overview of the term. Then we're going to go through what each panelist has sort of picked out as the cases they think are significant. And at the end of this, we will have at least 15 minutes for audience questions. And we will end at 5 o'clock, right on the dot. I promise. Seated to my immediate left here is Judge Gerard Lynch from the Second Circuit, United States Court of Appeals here in New York. It's impossible to do justice to what I could tell you about Judge Lynch's background. He clerked for Justice Brennan on the United States Supreme Court. He has been a professor at Columbia University School of Law since 1977, when he started at the age of 4. He has quite a storied history in the Southern District of New York's U.S. Attorney's Office, has been, among other things there, the chief appellate attorney of the criminal division. He was in the Office of Independent Counsel back when we had independent counsel, investigating the Iran-Contra events. He has been of counsel to various law firms in New York, and since the year 2000, he has been a life-tenured member of the federal judiciary, beginning on the district court in the Southern District, and then elevated, if you want to call it that, to the Second Circuit in 2009. I learned that last summer, he took senior status, opening up a position for appointment prior to the election in November, which you may have heard of. Seated next to him is Margaret Garnett. By the way, Columbia, both undergraduate and law school. So he's never left. He has had a Columbia ID since when?
1968.
1968, when he was -2. Margaret Garnett is an AUSA in the Southern District of New York, and she has been there for 12 years at least. She is the current chief of the appellate section, or the chief appellate attorney for the criminal division in the Southern District. And something I did not know when I signed her up for this panel, she was a law clerk to Judge Lynch when he was sitting on the district court. She too went to Columbia Law School, although she did leave town for a short time to get a degree undergraduate at Yale. She has served in various units in the Southern District, the Violent Crimes Unit, Organized Crime, and has been deputy chief of the appellate section. And she has also been an associate in private practice here in New York City. So we're really, and by the way, she's on vacation this week, giving us an extra day of her vacation, so I think she deserves a double round of applause. Finally seated to his left is Josh Dre Tel. Josh Dre Tel is a nationally prominent defense attorney, and I believe has been a defense attorney since he became an attorney.
Yes, that's correct.
He has, he's been past president of the New York State Association of Criminal Defense Lawyers, for example, co-chair of the amicus briefing committee for the National Association of Criminal Defense Lawyers, the NACDL. He currently serves as the NACDL representative to the Criminal Justice Section's Council, which is a national group of lawyers that sort of works on policy issues for the Criminal Justice Section. He has represented many people in very important cases that are labeled terrorism cases. He is in a group of lawyers that represent people in Guantanamo, He has received various awards for his work on behalf of people in Guantanamo and other related defense topics. He lectures, he's got publications all around the country. We couldn't have a better person to be here to tell us about the criminal side of the docket from the defense perspective than Josh Dre Tel. So I'm really very happy. Let's applaud right now for these guys because they're so good. That's before you've heard them say anything.
Yeah, that's a good time.
Right, afterwards, who knows? I'm Rory Little. I teach criminal law, federal criminal law, criminal procedure, legal ethics at University of California at Hastings in San Francisco. So I've never been anywhere near Columbia other than to walk past it on my way to some place else. I know nothing about it. And I do this review every year, so let me just say a few things that are non-substantive, right? The Supreme Court docket, as you probably know, was lower this year in argued merits cases than any year in the 20th century, any year since the Civil War, basically. They decided, they've granted review in less cases than they have in any recent time, and then they issued opinions in even less. And the reason for that, largely, was that they were down a justice the entire term. As you know, there were 8 justices. Justice Scalia died February a year ago. Justice Gorsuch was not confirmed until April of this year, and so the Supreme Court's docket was remarkably low. Of the, say, 62 cases that were decided on the merits after argument, roughly 24 were criminal law or criminal law related, which includes civil cases that might involve criminal law topics, such as the Ziegler case, which I'll talk about if we get to that. The court was divided 4-4 in some cases, and there are 2 types of cases that we see. First, 2 cases were set for re-argument on the last day of the term, and I think Margaret is going to talk about at least one of those, so we'll leave that for her. But it was set for re-argument, presumably because the justices were tied 4-4. There are other cases where the justices issued an opinion, but the opinion is remarkably narrow or sparse or somewhat uncontroversial because they punted on issues that they couldn't decide. So the 2 Fourth Amendment cases that, 3 Fourth Amendment cases all seem to me to be opinions that are easily identified as cases where they tied 4-4 on the hard issues, so they issued opinions to dispose of the case and remand on an issue that they could agree on. So when a Fourth Amendment case, for example, is unanimous, it's not unanimous because they were unanimous. It's unanimous because they found a very narrow ground on which they could agree on and then remanded on the others. So you'll see a fair number of those. This booklet contains summaries of all of the cases, but we will not discuss all of the cases. At the end of the booklet, there is a list of cases that are granted for next term, and some of us will talk about those as well. There are some big cases, obviously, up for decision in the coming term. I guess the last thing I'll say on the merits is that Justice Kennedy, at least up to now, and I think continuing, remains in the sort of deciding seat when the court is closely divided. And so there are certain opinions this term that were written by Justice Kennedy that are quite important. And he will be the deciding vote, I think, on the cases that are set for re-argument because they were set because they were 4-4. The other thing that I will say is Chief Justice Roberts has taken an interesting role on the criminal side. He is writing opinions on the criminal side and keeping the assignment because he has the power to assign on the criminal side. And to me, one of the most important cases is the case that the decision that he wrote in the Buck case. And I'm not sure if another panelist is going to discuss Buck, but the Buck case and the Peña-Rodriguez case both involve decisions where the issue of race bias was the central issue in the case. And what effect did that have on the other issues that might be present in the case? And in both of those cases, you will find some incredibly strong statements about race by the court in a way that I think reflects that this is an issue they can agree on. Justice Thomas did dissent in both of those cases. He was the only dissenter in one of them. But for the whole, this has become a third rail issue. If you can point to race bias in a case, you can get past some procedural hurdles that you might not get past in any other area. So it seems to me that's a significant moment, and the fact that the Chief Justice chose to keep the Buck case and write it and get his way past all the hurdles of habeas corpus, I think is quite remarkable. So with that, each panelist is going to talk for maybe roughly 10 minutes. We'll have some dialogue. If you have a burning question about a case as we discuss it, you can raise your hand and we'll call on you. You don't have to hold them to the end, but we will hold questions open for the audience at the end of the panel. So with that, I'm going to turn to Judge Lynch.
Okay, thank you. I'm on the clock, 10 minutes. I'm going to talk about 3 cases, I hope, that I can get through. So I'm going to try and be quick with them. The first is of interest primarily if you're a white-collar type practitioner, and that's Salman against United States. It's notable because it's a case where the court, the issue presented for certiorari on which the court granted cert was essentially, was the Second Circuit wrong with respect to what is basically a line of dictum in a case. And the Supreme Court decided that the Second Circuit was wrong in that. It's the rare case where they affirmed the Ninth Circuit even. So we were very wrong. Salman is an insider trading case. And the issue was, can someone be convicted of insider trading when the tipper, the person who was the insider, did not receive a personal financial benefit? So insider trading, as you know, is a kind of judicial construct. There's not a statute that defines it. The courts have defined it in civil and criminal cases, starting with Dirks against SEC, a civil case in 1983. And the polls that you want to bear in mind as the sort of simple cases are if I'm a corporate insider and I possess information that I have a fiduciary responsibility to the corporation to keep confidential, and I use it for my own profit by trading on that information, I'm guilty of a crime. On the other hand, if I am just a little loose-lipped, and while at the hairdresser's one day, I sort of mentioned some things about what I'm working on, and the guy in the next barber chair overhears it and decides, oh, that means that this stock of the company that I work for is a good or bad bet, and trades on that information. He's not guilty of anything, and neither am I. Because I didn't exploit this for my personal benefit. He's just picking up rumors on the street. Even if he shouldn't have had that information, it was just at worst negligent on my part. So those are the polar cases. The case that the Second Circuit had was a case called Newman, and among other things, the court said that unless the insider gets a personal financial benefit, there's not a crime of insider trading. The actual Newman case didn't require the panel, it seemed to me, to go that far. There was an argument. I bet that Margaret would disagree with that argument, but there was an argument that this was really just sort of people gossiping, and no one was intending that there be any insider trading. And the panel evidently thought that, and thought that the evidence was insufficient. But it did say in the course of the opinion that there needs to be a personal financial benefit. Fortunately, Judge Jed Rakoff of the Southern District of New York found himself sitting by designation on the Ninth Circuit. And he was a close follower of the Newman case and decided that this was his opportunity to do something about it. And he wrote an opinion in a case that I think is sort of should be a no-brainer case, and it proved to be a unanimous no-brainer case according to the Supreme Court. Salman is a remote tippee, but he's a family member of the guy who was the insider. And the insider told his brother some confidential inside information, and there was really pretty good evidence that the brother was something of a wastrel, and this was sort of in lieu of giving him money to help him out of his difficulties. The insider gave him some information, but the insider got nothing. personally out of it. The case seems to me to be very straightforward, going all the way back to Dirks in the very first insider trading case. In dictum, going out of its way, the Supreme Court said that insider trading can exist and a personal benefit to the insider can be found when the insider makes a gift of confidential information to a trading relative or friend. So there's some press that said, oh, this is like really expanding insider trading. It doesn't seem that to me at all. It seems to me to be restoring what the rule always was, that got a little upended in the Second Circuit by dictum that sort of ran the exact opposite. The basic line of reasoning was, if I'm the insider, I trade on the inside information, I make $100,000, and I give it to my brother, my mistress, my favorite charity, I'm still guilty of the crime. And there's really no difference if I skip the middleman and give the mistress, the brother, the favorite charity, the inside information and let them trade on it. So I think it's not as revolutionary a decision as all that, except that if you were sort of hopeful that insider trading law was going to be upended in the Second Circuit, no such luck, and that was a unanimous decision. Second case I want to talk about came out better for the defendant. This is Honeycutt against the United States. Hunnicutt was also in business in a much more minor way than Salman's brother-in-law. He was working as a sort of manager for his brother, who owned a sporting goods store in Tennessee, a hardware store. And they started noticing, he and his brother, that people were buying a lot of a product called Polar Pure. Which is apparently something that if you're a camper, I think if God wanted us to sleep in the dirt, he wouldn't have invented hotels like this. But there are people, I understand, who like to go out and sleep in the dirt and be in nature. And this Polar Pure is a product that you can put in the water to make sure you don't get poisoned. Better drink from the faucet, don't go out in the woods. But anyway, a lot of people buying an awful lot of Polar Pure, and it turned out that they were kind of breaking bad with it because this product could be used to make methamphetamines. And the brothers eventually came to the conclusion that, hey, it's not my business, let's just sell as much of this stuff as we can to whoever buys it. We're not making any drugs. The government took a different view and prosecuted them. What became interesting in the case and led it to the Supreme Court was not that they were guilty of some kind of crime for knowingly selling a precursor chemical or something of the sort, but was that there was a forfeiture provision in this statute. And the government decided to seek, and the district court awarded, and the Court of Appeals affirmed against Honeycutt, the junior brother, who wasn't the owner of the store, joint and several forfeiture for the entire sum of money that the store had made selling the product. And Honeycutt argued successfully to the Supreme Court. Interestingly, this also turned out to be a unanimous decision, that there should be no such thing as joint and several liability, that notwithstanding that there was a conspiracy, notwithstanding that the parties were both involved in the overall sales, the money went primarily to the owner of the store. And while there may have been something that trickled down to the defendant brother, Honeycutt, it was certainly not the total amount of profit that the store made on selling Polar Pure. A couple of interesting things about this from the standpoint of practitioners. Number one, in my experience as a district judge, defendants didn't pay that much attention to the forfeiture. Understandably, the main thing people are worried about is, I don't want to go to jail. The financial penalties are, for most people, secondary. But they still can be a serious thing. If you get a forfeiture judgment that's going to hang over you for the rest of your life, it may not seem so important at the moment when you think, I haven't got that kind of money anyway. It's not going to make any difference. Well, it may make a difference in the long run to your financial future. So I think, number one, defense attorneys should be conscious of forfeiture-type issues in cases. And Hunnicutt is a case where, as often happens, the Supreme Court wound up going against the consensus of a lot of the courts of appeals. The courts of appeals, we used to sort of routinely affirming these things, whatever happened. The Supreme Court is not that favorably inclined to forfeitures. And in this case, the analysis was kind of presents itself as a very straightforward, here's what the statute says, it doesn't say anything about joint and several, it has to be money that somebody made from the crime. But I think there's two things going on. One, that's an important thing to remember. Sometimes the emperors have no clothes. The district courts and the courts of appeals say things, but when you go right back to the statute, it turns out the statute doesn't necessarily support it, and you can make some headway with that. And secondly, forfeiture is not popular in the Supreme Court. The third case I'll talk about a little more briefly.
Can I just introduce, and that in terms of the practical impact of Hunnicutt, I think is potentially extraordinary in the context of plea agreements in particular, because in almost all respects, even in the most simple drug case in the federal courts, defendants who are indigent, who have CJA or federal defender attorneys, are saddled with hundreds of thousands of dollars of forfeiture judgments that they will never be able to afford. And if, in terms of the concept of mass incarceration, I look at many of these forfeiture judgments that are astronomical and not related to profit or any kind of personal gain by the defendant as sort of institutionalizing on a generational basis destitution. Because what happens is they get a judgment that 10 to 15 to 12, whatever the judge decides, and usually the 10% is the minimum of gross earnings that will go to the government when the person gets out. So think about the kind of job they're going to get. Think about how they're going to support their families, and how that's going to affect their abilities of their children to go to school or have other opportunities that people would have that you can't have when you're paying all this money to the government as a forfeiture judgment for which you never benefited. And so I think it has the prospect for real change on that level.
Yeah, and I would point out also, although it is distinguishable in part because there's different language in the statute, the possibility of extending this argument to restitution, which is another situation, of course not relevant in drug cases, but again, on the district court I saw a lot of cases where somebody was convicted for playing some small role in a larger fraud, often a person who was indigent, and the court said, well, you're on the hook for the restitution. And what's interesting is the sort of ringleaders who were professional criminals are never going to have any legitimate money to go after. But often the housewife, the working man, the person who's sitting at home accepting a package that was bought and the person knows was bought with a fraudulent credit card or that sort of thing, they're out there exposed. They're easier to convict. They wind up on the hook for a joint and several restitution. It's the same kind of thing. They're never going to be able to pay it. But that's going to destroy their credit rating, and it's going to leave them having garnished wages forever when they got rather little out of the crime. Now, again, I'm not opining on whether this would be a successful argument as applied to restitution. The statutory language is different, but I'm sure that lawyers are going to be conscious of making this argument in the future.
Well, if I just say one thing.
The clock is suspended while we all have our dialogue.
About Honeycutt, I think that another very interesting question is really where I thought you were going with the expansiveness, is that it's very unclear what the reach of Honeycutt is going to be, because the forfeiture, the narcotic statutes have their own forfeiture provision, and that was the provision that was at issue in Honeycutt, and the more general criminal forfeiture statutes have somewhat different language, and I think right now as practitioners it's very unclear, and I think the department is figuring out, its Department of Justice, its litigating position about what's the extension of Honeycutt to other kinds of non-narcotics criminal forfeiture, the opinions language, I think, about what does it mean to obtain money or property from the crime is very unclear, I think, what that's going to mean in practice. So as with many things that come out of the Supreme Court, there's a facial narrowness to the decision that I think awaits further litigation for people to figure out and wrestle with what is the reach of this decision really going to be.
One more aspect of this, again, going back to the literalism and the different language, the Supreme Court said the case was unanimous. The court was utterly unresponsive to a rather sophisticated government argument rooted in the nature of conspiracy law. And I think this is, from a standpoint of a part-time criminal law scholar, is interesting. The Supreme Court seems to have no concept of, or to be totally uninterested in, any general principles of criminal law. They treat criminal statutes as if they came from, and unfortunately with Congress they often do, it came out of the mind of Zeus, totally
Fully formed.
fully formed and unaffected by any principle or any notion that came before. So they'll just read the words sometimes. This is usually not good for defendants, by the way. In this case, I think it is better for defendants, but often they say, well, that's what the statute says, and they're somewhat reluctant to read into statutes some fairly basic principles.
Judge, this is not a panel just on forfeiture, but
Yeah.
I'll say two things. That's the problem with this, is every case you could do a
Please
full
don't
hour.
let it
on.
be a panel just
So,
over.
let me just say, at the very end, this is a unanimous opinion by Justice Sotomayor, and the problem with unanimous opinions from the Supreme Court is there's nobody dissenting to call the opinion into question, even on small details. So you can actually find a lot of unanimous opinions that are worse than opinions that are 5-4 and fully developed by a dissenting position. Sotomayor says at the very end, she says, you can't assign somebody, forfeiture liability for profits or money that they did not obtain. That's sort of out of the language of the statute. And then she says, she adds this phrase, or personally benefit from. Personally benefit from opens up a wide range of things, and compare it to the Salman case. The Salman case, the idea here was that brother who had inside information personally benefited by giving his other brother the inside information because he got his brother off his back. And that was his personal benefit. And a gift is personal benefit. Well, you can easily make the argument that Brother Honeycutt here, who was just a sales clerk at the front desk, personally benefited because, he got a vacation plan or good health benefits or whatever. It's totally...
Or the store just stayed open, made a profit, and he kept the job.
It's just, right. It's just totally opens up...
Nice for the family.
Totally opens up an avenue of argument for the government that might have been foreclosed had that phrase not appeared. The other thing I'll say, at the end of this booklet on page 36, there's a dissent, opinions that are issued when the court issues an order denying certiorari. So a dissent from denial of certiorari. We're not going to review this case. Justice Thomas, in a case called Leonard, which was in March, wrote a dissent from denial of review in a forfeiture case. It's a civil forfeiture case where he says, I'm not sure that our law of forfeiture is connected at all to the common law concept of forfeiture that should be governing our view, and I'd be prepared to revise, everything about forfeiture law. Now, he says that a lot about some things, but there's a sort of a warning shot across the bow, talk about hostility to forfeiture. Justice Thomas has expressed this view before. So if I were running the asset forfeiture section of the U.S. Attorney's Office, I'd be...
Well, I guess I'd also think, though, and this is a more general point, Justice Thomas does often say things like that, and that's why he is often dissenting solo.
Right.
Because he will often say, I'm prepared to take everything back to 1789. And even Justice Scalia had some sense that, things like Brown against Board of Education, you don't really want to be quite that much of an originalist. And so I'm not sure that that's a harbinger of the rest of the court going in that direction. But Justice Thomas certainly is prepared to rethink just about anything.
And his new partner, Justice Gorsuch, I'm sorry.
And Gorsuch has joined Thomas on a couple of things. That's true. The other case I just wanted to mention, it's important, I think, as a harbinger for federal practitioners, is Beckles against the United States. Beckles is part of the long, slow decline of the federal sentencing guidelines. There's a lot of technicality here, so bear with me for a moment. Beckles is a potential offspring, it turned out not to be, of a case called Johnson against United States, where in an opinion by Justice Scalia, the court found that a statutory federal definition of a crime of violence, it is language that appears in a lot of federal statutes with respect to sentencing enhancements and mandatory sentences, with respect to immigration law. It's a very significant case. We'll hear a little bit more about it in the immigration context later. Found that phrase as the definition of that phrase that is commonly used in federal law to be unconstitutionally vague. The exact same language shows up in a sentencing guideline, and it was applied to Mr. Beckles. Beckles took his case to the Supreme Court. This was a close one, sort of a 4-3 decision. Again, only 8 justices to start with, and Justice Kagan, I believe, was recused because she had been in the Justice Department earlier at some stage when the case was under consideration. But the court said, not unconstitutionally vague, because a sentencing guideline can't be unconstitutionally vague because the sentencing guidelines aren't important enough that we should pay attention to how they're worded particularly. After all, it's only guidance. Justice Thomas, who's writing for the court in this instance, said, well, you know, you used to have sentencing where there was no guidance at all. Judges could do anything they wanted on sentencing. So how could anything with sentencing be unconstitutionally vague? At least we're giving them some guidance in the guidelines. Interesting point. But I think what's significant here is that since Booker, as federal practitioners know, federal judges have reclaimed a lot of the discretion that they used to have in sentencing. It's an interesting sociological point. The guidelines are still there. They're still the first thing you have to do is calculate what the sentencing guideline range is. It's a factor to be considered. It has a lot of influence on judges, inevitably, because there you got a number. Does that number seem crazy to you? Maybe it does, and then you don't do it. But maybe it doesn't, and then the easiest thing to do is to apply a guideline sentence. So the guidelines still have gravitational force. But as a legal matter, the force is sort of leaking away from the sentencing guidelines. Judges are reclaiming this discretion. I think this is the Supreme Court sort of recognizing that and saying we're not going to sort of throw a big monkey wrench into something and make big constitutional law over something that's in effect only in the guidelines. So I think there may be other situations where if you're sort of counting on the guidelines to limit a judge's discretion, you may not be making much headway. But conversely, and this for defense lawyers is very important, only 1% of cases go over the guidelines in sentencing. But as much as half of the cases go under the guidelines, and about a quarter of those are cases where the government is not supporting it. It's not cooperators, it's not people where the government has made a stipulation to a lower sentence. The ability of defense lawyers to argue for lower than guideline sentences, I think, increases all the time. And even on legal issues, I think the court is backing away from taking the guidelines as seriously as they may once have been taken.
Well, and maybe I'll just pick up there on Beckles, because, to me, I think this point is right, although it's interesting because to me, Beckles illustrates this continuing tension on the court in the cases about what are we to make of the guidelines, what weight is to be given them. I definitely agree that for the past several years, it seemed like at all levels, courts had come to the view that, like, well, the guidelines are just that. They're a guideline, it's a starting point, but then after that, you can do whatever you want. And then last year, when Molina-Martinez was decided, which is another sentencing guidelines case at the Supreme Court, where all of a sudden, I think much to the surprise of Solicitor General's office and the practitioners generally, all this language about how the guidelines are the touchstone, the lodestar, errors in the guidelines are so weighty and important that we should have a presumption that it affected the sentence and it needs to go back for resentencing. And you see this in Sotomayor's dissent in Beckles, this frustration, right, of like, well, either they're incredibly important, the lodestar, the anchor, the way we evaluate every sentencing in the federal system, or they're not that important, but they can't be both. And certainly from a practitioner's perspective, I think, even though I totally agree, the dominant movement and theme is towards it's a starting point, and after that, do whatever you want. But then there are these detours, Molina-Martinez being one, that is, leaves us in this place where I think it's not really clear what weight is to be given the guidelines.
Well, when the guidelines are in your favor, it's easy for practitioners, right. It seems to me. When the guidelines are in your favor, argue the guidelines. When the guidelines are against you, cite all the other cases. The harder part may be for judges, but even there, I think the lesson is if you make a good record and do your job right as a district judge, it's going to be very hard to get reversed.
Bulletproof, right.
Yes.
I mean, and I think for those of us who are federal practitioners and are used to the guidelines, there was a kind of interesting bit of theater at the Beckles oral argument where, because I don't know how many people are federal practitioners, criminal practitioners, only a handful. So the sentencing guidelines are this really fat book, and as Jonathan knows, there's an endless debate about whether they should be simplified. Are they too complicated? Is it better to have the level of detail that they have? But at the Beckles oral argument, Breyer, you can't hear it on the audio, but you can visualize, he clearly has the guidelines open, and he's flipping through and asking defense counsel, like, well, what about this? More than minimal planning. Do you think that is too vague? What does that mean? Sophisticated means, picking out all of these phrases from the guidelines, like, is that unconstitutionally vague? You tell me, what does it mean? So it's just interesting about what.
Well, and that's going to
guidelines
that slops
are in the
over.
state.
Josh has something to say, too.
To the, I'm sorry, just one quick
Yeah,
sentence. That slops over also out of the guidelines to these vagueness cases, because Justice Scalia sort of revivified the vagueness doctrine. But you could go through the federal statute book asking the same questions. There are lots of things that are left to judicial elaboration, and I think one of the things about the passing of Justice Scalia, and we'll see where his influence persists and where it doesn't, is that basically he didn't like judges. He didn't like the idea that judges would have any discretion at all, and I don't know that that's as widely shared, but I think that's got a lot to do with the plain language aspect of Scalia's jurisprudence. To some extent, it has to do with the originalism, is to strip away discretion from judges to make interstitial law. But even in the criminal law area, it's hard to see how Congress can't write. And not because they're fools, whatever you think of the people in Congress, you can't anticipate everything and write it down in a statute. And that leaves room for administrators, it leaves room for judges, and that's the reality of life. Vagueness is a very tricky doctrine.
Josh, go ahead.
Yeah, on a practical level, not arguing with the the vagueness analysis in the opinion, but on a practical level, I do wish the guidelines were as unimportant as the Supreme Court thinks they are, in the context of the fact that while in New York we live in a bubble in the eastern and southern districts of New York, in which maybe 25% at most, I think we're down to about 22% of sentences being within the guidelines. Nationally, it's still about probably, I think, like 46 to 48%. We're still within the guidelines, and that's been decreasing since 2005, but it's basically steady now for the last few years. But the point being that, and there's a federal district judge in Iowa, Mark Bennett, who has been very vocal on this, and he's written a lot on the concept of anchoring, which is where you start, has a significant effect on where you finish. So if the guidelines are higher, you are fighting a much tougher battle to get down to what you might consider a reasonable sentence as a defense attorney than you do if you're 2 or 3 levels below, which could be anywhere from 1.5 years to 2, depending on where you are and what the criminal record is. And not to go into it, but it's a 2-axis graph that intersects with levels and criminal history. But the point being that the guidelines act as a benchmark in every case, and there are very, very few judges who will take an independent look that does not have the guidelines as an anchor. And outside New York, it's a much more serious problem.
Of course, from my standpoint, that's sort of where we should be and where we should have been, in the sense that, remember, back before Booker, that percentage was something like 78%, and the only ones that weren't guideline sentences were ones where the prosecutor was going to bat for the defendant, which is not your usual situation if you're a defense lawyer. So we've gone from one extreme, from the extreme of total judicial discretion, I'm old enough to remember that, to the, in the federal system, to the era when judges had very little discretion, to now something that is more of a hybrid. And it's always seemed to me that there is, like, look, are we going to have a war on drugs? I sort of wish we didn't. But that's not my job. If you ever can imagine a Congress that decided to say we're not going to have a war on drugs, if judicial discretion is so total, the problem is we can still have a war on drugs in his courtroom if he wants to, and not have one in my courtroom if I don't want to. There should be some anchoring. There should be some national policy that says we do take this seriously. We take that a little less seriously. Whatever it is, whether you like that policy or not, the biggest problem with the federal guidelines is they're so severe. It's not the concept that we have guidance, and that by and large, when you get that guidance, judges welcome the help. Because how on earth do you decide whether 2 years is too little or 5 years is too much in a case?
Well, I certainly think it's true that there's a overweighting of the benefits of judicial discretion in sentencing, because I think even though it's true in the district that Josh and I both practice in here in Manhattan, that most sentences are below guidelines, but there's tremendous disparity within our district from judge to judge. And for me, even as a prosecutor, just thinking about the fairness of the system as a whole, it's not a compelling case to make that such enormous role should be played by the name that comes out of the wheel when your case is returned by the grand jury. And I think we are in that situation in our district where
now, this reminds me
tremendous variance.
that next year we will have a state practitioner on the panel. Let me just give you a little bit of inside baseball spin here. There was in this case a guideline commentary which said the specific crime at issue, possession of a sawed-off shotgun, is a crime of violence. It wasn't vague at all. That narrow ground was available for decision. But only 2 justices said we should go for that, Ginsburg and Sotomayor. And Justice Thomas was anxious to say something broader about the guidelines. And then you say to yourself, where was Justice Breyer? Justice Breyer, the guidelines are his child.
Right, the original.
He is the guidelines guy. He thinks they're very important. I don't think you can read this as purely, oh, the guidelines aren't that important. Here's Breyer's take. This is I have no idea what his real take is. I'm making it up. But Breyer's take is, I think the guidelines are great, and they're so important and so well written that we should have no challenges to the guidelines. And if the due process clause is going to give them a challenge, they're out of here. So he is silent in this case. So I actually think there's another way to read this case, as suddenly the language of the guidelines has now become very powerful because you can't challenge them under this decision, under the due process clause.
I would, as defense.
But then we're going to stop and we're going to go to Margaret after you.
But as a defense attorney, I would flip that around to judges and say, look, the language is the language. We can't even go. So to that extent, discount the guidelines altogether, because you can't get underneath the hood of the guidelines and start challenging the language, because that
works well in San Francisco,
right, and New York too in many respects. But the thing my problem, and I'll just be brief, is in some sense language and nomenclature, which is to have a non-guideline sentence now. It's called a variance in many respects. To me, it's not a variance. It's a non-guideline sentence. The guidelines do not dictate the sentence. They're one of 7. Yeah. The Supreme Court says it's one of 7 factors which are non-hierarchical. So in the sense of saying it's a variance already assumes that the guidelines are governed. So to me, that's one of the fundamental problems to get judges to move away from that.